Hi, everyone. Thanks so much for joining. Welcome to our webinar today titled MAiD in Dementia with Dr. Dirk Coetsee. At the Society, we receive many questions about medical assistance in dying, also known by the acronym MAiD. And our goal today with this webinar is to help provide information about MAiD as it relates to people living with dementia. This webinar is part of our larger end-of-life webinar series, and previous sessions have included other end-of-life topics such as palliative care and advanced care planning. So my name is Avery. My role is the Provincial Coordinator for Policy Analysis with the Society. And so we're really thrilled to be joined by our presenter today, Dr. Dirk Coetsee. Dirk graduated from Stellenbosch University in South Africa before moving to Edinburgh, Scotland, where he completed his general practitioner training, his MRCGP, and continued to work as a GP in the National Health Service for the next 8 years. He relocated to Canada in 2016. From 2021 until August 2022, Dirk was the medical director for the Assisted Dying Program with Vancouver Coastal Health before stepping down to return to his passion of providing patient care. Dirk's current clinical time is split between working as a GP in an inner city practice, providing care to marginalized and complex patients, and being a MAiD provider. He has a teaching affiliation with the University of British Columbia, and Dirk's aim is to support equitable access to MAiD for all patients. Thank you again for your presentation today, and over to you, Dr. Coetsee.
Thank you so much, Avery, for the introduction. And just before I get started, I'd like to respectfully acknowledge that the land on which I live and work is the unceded and traditional territories of the Coast Salish peoples, which includes the Musqueam, Squamish, and Tsleil-Waututh people. I'm very grateful to the original stewards of this land, and I encourage you to take a moment to reflect with regards to the history and legacy of the land from which you are joining us this afternoon. Today, we are going to familiarize ourselves with the MAiD legislation in Canada and the history of it. We're going to review the eligibility criteria, discuss how eligibility assessments are undertaken, and then review the nuances of MAiD in dementia before we review 2 cases. We will then open up the floor for questions. This is a lot of information to cover in 1 hour, so let's delve straight in. Kay Carter was a resident of BC who travelled to Dignitas in Switzerland, where she had an assisted death on the 15th of January 2010. Her family subsequently challenged the prohibition of assisted suicide in what would become a landmark Supreme Court of Canada ruling in 2015. This led to the introduction of Bill C-14 in June 2016, which amended the Criminal Code of Canada to allow clinician-assisted death. However, under Bill C-14, only those with a reasonably foreseeable natural death were able to qualify for assisted dying. We will review the definition of reasonably foreseeable in another slide, so if you have questions about that, please hold that thought. Through a legal challenge in Quebec in 2019, it was found that Bill C-14 was unconstitutional as it was discriminating against people's sources of suffering based on how reasonably foreseeable their death was. When the government took on changing the bill in accordance with the Quebec finding, they took the opportunity to make additional amendments to address many of the issues raised since MAiD became legal in 2016. Bill C-7 received royal assent on the 17th of March 2021 and replaced Bill C-14. To be found eligible under Bill C-14, an applicant had to have a grievous and irremediable medical condition, their natural death had to be anticipated in the foreseeable future, and they had to be in an advanced state of decline. Their suffering had to be intolerable to them. Here it's important to note that it is not what a clinician or a family member felt was intolerable, but what the patient themselves found intolerable. So this is a very patient-centered approach. This suffering also has to be credible to the clinician assessing someone. They have to be a competent adult, meaning they have the ability to take legal decisions about their own care at the time of their assessments and at the time of their assisted death. There was also a 10-day reflective period from the day they signed their request forms. During these 10 days, they could have their assessments, but not yet go ahead with an assisted death. The 10 days could be shortened if they were at risk of losing capacity or the ability to take decisions about their care, or if their death was imminent before the end of the 10 days. Going back to someone's death being natural death being reasonably foreseeable, there was no firm definition provided as to what it meant, and no time frames attached. When this happens, there is uncertainty for healthcare providers and non-standardized practice. Providing an unlawful made death could mean a criminal investigation, suspension of a practitioner's license by the governing body, and even incarceration. This uncertainty led to a legal challenge in Ontario in 2017, which is known as the I MAiD case. Reasonably foreseeable death, natural death, is a term that has only been used since the introduction of Bill C-14. This applicant's identity was protected, and she was only referred to as AB. The 77-year-old lady applied for MAiD in early 2017 and was told she was eligible. However, the decision was subsequently reversed 3 times. Why? There was uncertainty about the foreseeability of her natural death. AB's source of suffering was osteoarthritis, and she had a life expectancy of another 10 years. I couldn't imagine how I would feel if I thought 3 times that I was eligible for MAiD and had a way to address my intolerable suffering, only to be told that it was no longer available. On the 19th of June 2017, AB was vindicated when Justice Paul Perrell ruled that she satisfied the reasonably foreseeable natural death requirement. In his ruling, Justice Perrell took aim at some of the misconceptions surrounding the reasonably foreseeable requirement. He clarified by highlighting that someone does not need to be terminally ill to qualify. They do not need to suffer from a fatal medical condition. And Justice Perrell made it clear that providers need not opine about the specific length of time that a person requesting MAiD has remaining in his or her lifetime. With a comforting knowledge that other Canadians in her position would benefit from this ruling, AB went ahead with an assisted death in early 2017. I just want to quickly run through the full eligibility criteria before we move along to the assessment process. So currently, someone has to be at least 18 years old. So there's no route for mature minors at this time. Someone has to be eligible for publicly funded healthcare services in Canada. So usually that means you're either a citizen or you have permanent residency. And this stops health tourism. Someone has to request assistance in dying voluntarily and without pressure or influence from anyone else. They have to be capable of making their own healthcare decisions. They have to give informed consent to receive MAiD after they've been informed of all the means available to relieve their particular suffering, including palliative care where appropriate. So it's important to note that we are unique in Canada in that someone doesn't actually have to accept specific treatments. As long as they're fully informed of their treatment options, they can decide which treatments they wish to pursue, and they don't have to pursue any of them. Further, someone has a grievous and irremediable medical condition. And this is broken down to clarify to say that someone has a serious and incurable illness, disease, or disability. Someone's in an advanced state of irreversible decline. And that illness, disease, or disability, or state of decline causes them enduring physical or psychological suffering that is intolerable to them and cannot be relieved under conditions that they find acceptable. So when Bill C-7 was introduced, a sunset clause was built in. So this is a clause that was automatically removed after a certain time. This clause states that mental health conditions are not currently considered an illness, disease, or disability, and this is repealed on the 17th of March 2023, or 2 years after the introduction of Bill C-7. It's important to note that conditions like dementia are specifically excluded under this clause. Also, it doesn't mean that someone who has a mental health condition is excluded from accessing assisted dying. Someone with cancer who also has schizophrenia could still be eligible. The sunset clause refers specifically to those applying who have a sole underlying mental health condition causing them intolerable suffering. This next slide is an overview of the MAiD journey. Every health authority in BC has a care coordination service that manages MAiD requests and links patients to MAiD providers. There is no need for a GP referral, and sometimes people choose to self-refer without the knowledge of their GP. People can self-refer by downloading the form from the BC government website. If you enter into a search engine, MAiD Forms BC, it should be the first link that shows up. Now, I recognize that there are people from other provinces and other geographic areas joining us today. So your own area will have, if you Google your own service, it shouldn't be too difficult to find the forms. There are 2 types of MAiD assessments that are undertaken. The assessor would usually only complete an eligibility assessment. So they could be someone's family physician, oncologist, or neurologist, but it can also be a clinician from the MAiD program. The provider assessment is undertaken by the physician or nurse practitioner who would see someone through the journey if they ultimately decided to go ahead with an assisted death. They are called the provider, as they would provide the assisted death for the person. Providers can assess someone via video link, or they can visit someone in their home to complete the assessment of eligibility in person. We will often meet people in the hospice or in the hospital setting as well. If we take a closer look at this infographic, you'll notice that the patient inquiry is separate from the rest of the process. This is due to not all advice calls to the coordination team resulting in a request form being submitted. However, if someone does complete and submit a request form, and it is returned to the relevant health authority coordination team, they would then reach out to the person to obtain some more information before linking them to an assessor and provider. The next step is to have 2 assessments completed. You'll notice on the slide it states a minimum of 2 assessments. The reason for this is that when someone is found ineligible, they have the right to request further assessments until they have 2 assessments that find them eligible. The next step is again not linked to this step, as only about half of people who apply for an assisted death end up going ahead with a procedure. For many, the knowledge that there is a way out can help them for the intolerable to be tolerable for longer. After someone has passed, we would offer support to families by linking them to existing support services like hospice counselors. And if someone had their MAiD in a hospital or a care facility, we offer support and debriefing to staff who often struggle to negotiate their own beliefs and perhaps moral distress about MAiD. You'll see below these steps, there's a blue line stating healthcare team continues to provide usual care. This means that no changes should be made to someone's care simply because they've applied for MAiD. No clinic follow-up or planned scans should be cancelled, and no medication should be discontinued without discussing it with the person first. Now, this next slide is reviewing the tracks that's available under the current legislation, so under Bill C7. So this track that's on the screen now is what has been the route that's been available since the introduction of Bill C14 in 2016. So this is for those people who do have a reasonably foreseeable natural death. So before the change in the law, someone had to have 2 witnesses sign the request form with them, and that has been reduced to 1, which reduces barriers for people to getting their request form submitted. So before there was a 10-day reflective period, as I discussed earlier, it was found that most people have usually given considerate reflection before they apply for assisted dying. So if someone is already suffering intolerably and they're now told that they have to wait 10 days before going ahead, the government was extending someone's particular form of intolerable suffering. This group now has access to a waiver of final consent. And we're going to come back to this in a future slide. So I will give you more information about the waiver of final consent shortly. So the next group is those who do not have a reasonably foreseeable natural death. So again, for this group, there is only 1 witness needed. And this group is usually people who are younger, who maybe have conditions like chronic pain, fibromyalgia, maybe central sensitivity, conditions that really affect someone's quality of life, but doesn't actually shorten their life expectancy necessarily. So this group has a 90-day minimum assessment period. There is an expert consultation needed. And now for a bit more information about that, one or both of the assessors must have expertise in the condition causing the person the most suffering. And if neither of them do, then they have to consult with someone with expertise. The clinician with expertise does not need to be a specialist or have obtained certification. They could have developed their expertise through experience in treating patients with a particular condition or have received training on that condition. This can be a nurse practitioner or it can be a physician. This broad definition is allowed to allow better access, as it's recognized that waiting lists to see specialists are often long. The 90 days may be abbreviated if someone is at risk of loss of capacity. And it's important to note as well that those in track 2 do not have access to a waiver of final consent. So someone can move from track 2 into track 1 if their health changes and their death becomes reasonably foreseeable. So now that I've mentioned the waiver of final consent, let's look a little bit more detail into what that is. A waiver of final consent is an agreement between a provider and a patient who has been found eligible for MAiD who wishes to set a date to proceed with an assisted death should they lose the ability to consent to having MAiD. A delegate decision maker is not involved in this process. By contrast, an advance directive is a statement that is either set up with a lawyer or someone's family physician. It is not specific to a specific clinician, and it cannot be used for MAiD. Its only application is to refuse certain care options. A delegate decision maker is involved in this process. So we're going to discuss waivers in more detail a bit later on in the context of MAiD, but now I'd like to review with you the uptake for assisted dying in Canada. So you will notice a steady increase year on year since 2016. Of course, in 2016, MAiD was only available since June. As we discussed earlier, only about half of people who apply for MAiD actually go ahead with an assisted death. So for many, it is simply a back pocket option. So MAiD can be accessed at short notice. We don't anticipate this increase to continue at the same rate, and over time, the numbers will start to even out. With regards to MAiD and dementia, there is a common misconception that those living with dementia are not eligible for MAiD. However, there has never been an exclusion to those living with dementia or cognitive decline. All eligibility criteria have to be met, and I'd like to discuss the more challenging ones with you. It is important to recognize that people living with dementia may often have other conditions that may support them accessing MAiD, which could be conditions like heart disease, lung disease, or even frailty. For the purpose of this discussion, I will focus more on those applying solely with a diagnosis of dementia. The law, of course, states that someone has to be in an advanced state of irreversible decline. So this means that someone with mild memory loss is unlikely to qualify. They would usually need to have more significant impact on their daily lives. They may need support with managing finances, managing their home, or their personal care. However, we do take someone's prior functioning into account as well. At the time of assessment, someone needs to have the ability to give consent to receiving MAiD, or as we refer to it in medicine, have capacity. We will look at capacity in more detail on the next slide. Their suffering has to be intolerable for them, which is, of course, either physical or psychological. This one is one of the biggest challenges around MAiD in dementia. As someone's dementia progresses, not only do they lose the ability to recognize what they've lost and how it's affecting them at the time, but they also gradually lose the ability to recognize anticipated future suffering. Now let's look a bit closer into the assessment to establish whether someone is able to consent to having an assisted death. This is part of the MAiD assessor's assessment of eligibility. Assessment of capacity is specific to specific treatments. So the assessment for capacity for MAiD is to assess whether someone is able to consent to receiving an assisted death. When doing the assessment, we look at 4 components: communication, understanding, appreciation, and reason. Communication. This is where the person tells me how the condition affects them, how they're suffering, and what the reasons are for them wanting MAiD. Understanding. This is understanding your own context of how the condition affects you. I used to run my own business, but now I'm unable to do my personal finances. I misplace things all the time. I can no longer read books, or I lost a significant aspect of my independence when I had to give up driving. They also show that they understand what the future holds for them. Appreciate. What are your different treatment options? What are their options if they don't decide to have an assisted death? How would they receive care? Would they manage with home care, and for how long? And would they be okay with going into a long-term care setting? And of course, what is their understanding of the implications of accessing an assisted death? Reason. This is where the person demonstrates the ability to weigh the pros and cons of each option, displaying the ability to express why they're choosing to have MAiD over other options available to them. The capacity assessment is an overall picture that the provider builds of the interaction throughout the interview. The Dutch have been providing assisted dying for much longer than we have here in Canada, and they have an approach called 10 to midnight, with midnight being the point at which someone loses the ability to give consent to access assisted dying. The provider would follow someone at regular intervals and highlight to them when they feel that they're approaching a now or never point in their illness. Not everyone agrees with this approach, as it is not without pitfalls. My general advice to someone is that when you wish to access MAiD due to dementia, and it is very important to you that you access this care option, you should prepare yourself and your family that you would likely need to do so earlier than you would otherwise if you maybe had a condition, for instance, like cancer. Something we're often asked is, what if someone has no recollection of prior meetings? Capacity is not all or nothing. It may fluctuate. It's been described as a photograph in time, not a video. If they forget two hours later, but we have the same interview again and their wish remains consistent, then MAiD remains an option. However, with fluctuating capacity, there is a risk that someone may not be able to consent on their MAiD day. I remind patients whom I follow who live with dementia of the warning signs that they're approaching a time that they're more at risk of losing capacity. Sundowning is one of these conditions. It refers to a state of confusion occurring late in the afternoon and lasting into the night. Sundowning can cause different behaviors, such as confusion, anxiety, aggression, or ignoring directions. Sundowning can also lead to pacing or wandering. Delirium is a confused mental state which occurs suddenly. A person has a change in their mental status and acts disoriented and distracted. Delirium is more common in older adults, especially in those with dementia. Prompt treatment is essential in helping a person with dementia delirium recover. Now, we've already reviewed the definition of a waiver of final consent, but I'd like to add it to this slide as a reminder. There is no blanket exclusion to say that a waiver of final consent could not be applied in dementia, but not all providers are comfortable to use a waiver in this setting because the application has turned out to be far more complex and challenging than anyone could have anticipated when the legislation was first introduced. When setting up a waiver of final consent, we discuss what the possible triggers would be that would invoke the use of a waiver. For some, it's losing their independence and needing to rely on others for daily activities, like dressing, feeding themselves, or bathing. For others, it may be a different version of losing their independence when they need to go into a long-term care home. A common suggestion is not being able to recognize my family members. However, this can be a very late change. It is important to keep in mind that a waiver is specific to the physician or nurse practitioner that draws up the agreement. This means that no one else can step in and provide to someone using a waiver of final consent drawn up by a colleague. We also have families and we need a time away from work, so we may not always be available at short notice. To me as a provider, one of the most challenging requirements in dementia for someone to be able to proceed with an assisted death is that their suffering is intolerable to them. If someone has lost the ability to recognize their suffering and they're happily sitting and watching reruns of TV shows without any awareness of the content of the shows or of their own suffering, how could we argue that they are suffering intolerably? If 2 years before they could have imagined that this would happen for them in future, then it could have caused them intolerable emotional suffering then. But now they appear to be completely unaware. So in this setting, even if someone has a waiver of final consent, it would be difficult to justify going ahead with an assisted death. One of the requirements specified in the legislation is that the provider has ensured that the person has not indicated by words, sounds, or gestures that demonstrate refusal or resistance to having the substance that will cause their death administered. This safeguard applies even when someone is confused. I tell patients that you can always say no to MAiD, but your opportunities to say yes become more limited over time. Understanding some of the challenges around the use of a waiver of final consent, I'm sure you would agree that having a waiver of final consent in place is by no means a guarantee that someone would be able to access an assisted death. I'd like to review with you 2 patients whom I followed for MAiD. Their stories are real, but I've anonymized their details so they cannot be identified. So we'll call the first lady Sophia. She was 85 years old at our first meeting. She was living independently. She was traveling to visit her daughter on her own in another province. I would describe her as being fiercely independent. Her trigger she identified during our interview was that she lost her independence and she was having to move out of her own apartment. She agreed for me to speak to her daughters to obtain background information. We agreed to follow up every 3 to 6 months. It actually struck me how well Sophia was functioning for someone who was living with a diagnosis of dementia, and how clear she was about when she would want to proceed with MAiD. So I followed her up every three months, and 18 months later, Sophia was misplacing items. She had lost her wallet in her home, and these things were causing her significant distress. She was no longer able to go cycling. She had to give up the volunteer work she was doing, and of course, COVID had started as well, and she was unable to travel to visit her daughter. So Sophia had reached that point where she needed to move into assisted living, but she was not yet requiring long-term care. So she was really at that point where she was so clear before that she would want to proceed with an assisted death. Her family and I were therefore equally surprised that she did not want to pursue an assisted death at this time, and she wanted to move into assisted living. We reviewed that the window for accessing assisted dying was diminishing for her. I met with Sophia right after she moved, and she was really enjoying the new environment. She was enjoying activities offered, and she was able to go for walks outside. So fast forward to our last meeting, which was 9 months after she met. Sophia was now barely managing in assisted living. She was having significant anxiety, she was struggling to dress herself appropriately, and she was needing a lot of reassurance from staff. She had some episodes of incontinence, which she found really distressing. On reviewing her options with her, she was unable to reason about her wishes. She simply stated that she wished to remain where she was, and she couldn't understand why she wouldn't be able to stay in assisted living forever. So her daughter and I had been meeting with her together, as her daughter could help to give her context and provide me with more information about her functioning and about her difficulties. So when I asked Sophia under which circumstances she would wish to go ahead with an assisted death, she indicated that she was no longer wishing to have MAiD. So in this situation, even if she had a waiver of final consent in place, I would not have been able to provide an assisted death for her. This is definitely some food for thought here. I'll refer to our next lady as Annette. So very similar to Sophia, Annette was 84 when we first met in February 2021. Her two daughters joined for the assessment, one in person and one virtually. Annette had been diagnosed with mixed Alzheimer's and vascular dementia. She also was misplacing things in her home, thinking she was burgled, and she'd given up her driver's license 3 months earlier after she got lost whilst driving. Her daughters had noticed that she was forgetting conversations she had with him. As with many people I meet in this role, Annette had lived experience and that her father had dementia, and she saw what his journey looked like through his final years. Her father had asked for help to die, but MAiD wasn't available then, and he lived to 92 before he died in a long-term care home. For now, Annette was doing her own shopping, and she was going for walks. Her daughters were helping her with finances, medical visits, and ensuring that she attended other appointments. We reviewed the signs of progression, including the 10 to midnight approach, and then Annette would be at risk of losing access to this care option if she waited too long. At our first option, Annette made a very profound statement. She said that if she was no longer able to be present mentally, she wished to be tucked away in a coffin, not tucked away in a hospital. Annette also gave me consent to obtain information from our daughters. We continued to meet every 3 months and discuss the option of a waiver of final consent after the introduction of Bill C7 in March 2021. Now, we continued to meet every 3 months, and every time I noticed a gradual decline in Annette's functioning. Initially, she had no recollection of our prior meetings, but one thing remained consistent, and that was that her independence was paramount to her, and she always said that she wanted to have an assisted death over going into long-term care. In August 2021, we completed the first waiver of final consent for her. When I reviewed her in November 2021, we decided to complete the waiver for 6 months this time. When we met in February 2022, Annette had gotten lost whilst walking, and she started confusing her daughters with each other. We again reviewed that we were approaching a time where she would have to go ahead with MAiD, or the option of an assisted death may be lost to her. She again was very firm in her expression that she wished to have an assisted death over going into care. So we're moving on to April in 2022. And Annette was home alone. She had some food on the cooker that she left and triggered the fire alarm. She was found disoriented and she was admitted to the hospital dementia unit where she was sundowning with distress. And you recall the sundowning that we discussed earlier, which is a state where someone develops more confusion later in the day leading into the night. So we were scheduled to meet early May for a renewal of final consent, a waiver of final consent. So I had just returned from vacation and I initially attempted to meet with Annette on the Friday afternoon. However, she was already sundowning at this time. So on the Monday morning, I met with Annette and her daughters on the ward. One was in person and the other one, who didn't live locally, joined us again over speakerphone. Annette recognized me and she could tell me why we had met before. Further than this, though, she wasn't really able to express her wishes or conceptualize life in a care home. Her daughter mentioned to me in private that she'd been looking at care homes the previous week and felt that it would be her mom's worst nightmare. We discussed at this point that the waiver of final consent was expiring 3 days later, and its daughter, who wasn't living locally, decided to get on the next flight to Vancouver that she was able to book. And its daughter also mentioned to me that one afternoon during her mom's admission, she called her and asked her for help to die. Her daughter went straight to the hospital and her mother had a good hour of clarity where they were able to discuss her wishes. So the next morning, we met again in the hospital. This time, me and both of Annette's daughters in person. At this time, Annette was able to retain information and she again expressed the wish that she preferred to have an assisted death over going into care. After this, we drew up a plan with the support of the mental health team. So the plan that we formalized was that Annette would be discharged home in the care of her two daughters. She would be decertified, meaning that she would no longer be detained under the Mental Health Act. However, the hospital agreed to keep her bed open so that in case she needed to go back into the hospital, she wouldn't have to go to the emergency department and she could go straight back to the ward. So the plan was for Annette to have one night at home with her daughters, and the ward managed to secure overnight private nursing support. I was working in clinic the next day, so I had a full day in clinic and I kept checking in with Annette's daughter through the day. So when we spoke at 10 o'clock in the morning, Annette's daughter told me that her mother didn't sundown the night before. They had a lovely evening, they drank wine and they danced to ABBA in their living room. In the afternoon, I checked in with her again. They'd gone for a walk, they were out for lunch, and when they got back home, Annette said that she felt tired and she was going for a nap. When she woke up, she felt a bit disoriented and she said her head felt full and she tried to leave the apartment. Her daughters managed to help to get her settled down and she was comfortable and sat with them. When I finished clinic, I arrived and I went into her home on my own first. Before I arrived, I discussed the plan with her daughters, and we decided that because she was clearly starting to sundown, we would not aim, and we felt that she wasn't able to consent to having the procedure. We agreed that I would arrive and I would just offer her medication to help to keep her settled and help her to feel comfortable. When I arrived, Annette was comfortable to have me in her home, and she allowed me to administer the medication for her. We saw her through to her bedroom, so she had to lie down in her own bed. I administered the medication, and once she'd rested off, the support nurse came through, they fitted the IV access, and we went ahead with her assisted death. So Annette passed away very peacefully in her own home with her two loving daughters by her side. So after her death, Annette's daughter forwarded me an excerpt from her advance directive. Now, of course, we've discussed that this is not something that currently holds any value legally in terms of accessing MAiD. However, having access to this really helped me to feel that I had honored her wishes. So I'd like to read this out to you now. I wish to remain as independent in my choices and living arrangements as my mind and body allow. My greatest fear is to be kept alive in a collective dwelling while my mind and freedom erode. For this reason, I do not want any active treatment or interventions such as resuscitation or other heroic measures undertaken to sustain or prolong my life, especially if such means may limit my ability to communicate or move about freely or could increase the cost and burden this may place on my family or my estate. I believe that the indignity of deterioration, dependence, and hopeless pain is to be feared more than death. I therefore ask that medication to be administered to me to alleviate my suffering, even though this action may hasten my death. If there is no reasonable expectation of my recovery from physical or mental disability, and my natural death is foreseeable but not forthcoming, I wish to be assisted to die by euthanasia. So I just also want to say that Annette's family had given me consent to share this in presentations. So her daughter explained to me that while she recognized that this does currently not hold any value, it was very important for her to draw this up. So she spent many hours hashing out the finer wording of this with her lawyer. So yeah, I would say it really helped me to feel comfortable in the knowledge that I supported her and honored her wishes, and that this is something that she had discussed with her family over a long period of time. So before we open up for questions, I'd like to share with you a few patient quotes of people I've treated and whom I've met over the years. So the first is from a gentleman who was 93, who told me, "The quality of my death is as important as my quality of life." Someone who was 98 said, "I loved living, but I'm suffering so much. Please let me go." He actually said, "Please, please let me go." Next is a 91-year-old lady whom I met in a palliative care unit. She said, "I'm not scared of dying, but I'm scared of getting there. MAiD is the ultimate act of compassion from one human to another." And I'd like to highlight that this lady didn't actually access assisted dying. A few weeks after we met, she passed away naturally in the hospice. So for her, it was just the knowledge that there was that way out that was so comforting. And the last one is the lady who was 71 who had had a debilitating stroke. She said, "I cannot live in this body anymore. It's breaking down. It's breaking apart. I choose not to live in it anymore. I'll go out with a smile on my face." And with that, I'd like to open the floor for questions.
Thank you so much, Dr. Coetsee. Yeah, just a really wonderful presentation, and I think really helped to walk people through the steps, understand the legislation, and also a look into some of these personal stories that I think we're all honored to hear today. So thank you. I do have a few questions, and I'm sure more will roll into the chat, so I'll just get us started. So one question here is, I would like to know, once a MAiD waiver, I assume that's waiver of final consent, has been completed, how long is that good for?
So the waiver, and this is something that will be depend on the local guidance, but also on what a provider feels comfortable with. So again, similar to a reasonably foreseeable natural death, not having any time limit attached to it. For a waiver, the legislation doesn't actually have any specific time limit. However, we do need to be careful to use it as a waiver of final consent and not as an advance directive. And of course, we highlighted those differences. So the longer we use it for, the more someone can argue that we're using it as an advance directive. So for most providers, experienced providers, usually the comfort level would be around 3 or 6 months. So I hope that that would answer your question. And certainly for someone with dementia, as I mentioned, it's really important to make sure that we follow someone regularly so that we can highlight when there is a change and when it's more important for them to consider going ahead with an assisted death. If that window of being able to consent is closing, just taking into consideration the risks by relying on a waiver to have MAiD.
Thank you. And a quick clarification here about the waiver, that someone's asked, to whom should we give this waiver? Lawyer, family, holder of advance directive. So to confirm, this is something you enter into with a physician.
Exactly. So it would be with a physician or the nurse practitioner, and it would be, so they would hold on to it and they would enter it into someone's medical chart. You can also ask for a copy of those. So the family can ask for a copy with a consent of the person. And I suggest to people when I issue the waiver and when I send them a copy, I suggest if you have a no CPR form on the fridge, please put it in the same envelope, keep it on the fridge, because my phone number is in there. And if a paramedic crew came in and they saw you, they can update me about your condition. So certainly, I would say you can provide copies to anyone that you feel comfortable for having a copy. And I'd also like to highlight that with a waiver of final consent, because it's not anyone else giving consent for the procedure, someone's family or caregivers are reaching out to the provider, but they're asking the provider to decide whether that person has reached the point that they discussed and where they agreed previously that that person would want to go ahead with an assisted death. So loved ones are not making that decision. They're simply reaching out and saying, could you please come and assess them because we may be at that point that we discussed before.
Thank you. And adding on to that, because you just brought in family members, I wanted to bring up a question that was shared with me before the session. So they said how to cope with family members that want to revoke the agreement or consent. Should family members be one of the witnesses?
Yes. So the law is very clear on this, that this agreement is between the clinician and the patient requesting MAiD. So there has been some instances where family members have tried to stop someone going ahead with an assisted death, but it's something that ultimately lies between the provider and the person wishing to access MAiD. So while the family member can't cancel the waiver of final consent, what I do see is that people are sometimes pressured by relatives or by friends to cancel their waiver of final consent or to cancel their request. So there is protection in the legislation for people to not be pressured into accessing assisted dying, but unfortunately there is no protection for someone being pressured to cancel the request. So that is the type of coercion that we do see. And that is where, as I mentioned, with someone's suffering being intolerable, it's what they find intolerable and not what a loved one or a friend would think should be the point where they should access an assisted death. So it's really specific, patient-centered, and someone legally can't, or they can apply to the courts, but and an issue that we can sometimes run into is if we show up at someone's house to provide an assisted death for them, then a family member may stop us getting access to them. So that is something that we would then need to involve the police, but it can then cause a delay. So that's also a discussion that I have with someone when we set up a waiver, is there's no guarantee that I can provide you with an assisted death, because if your family stops us from getting to you, then we might not be able to provide for you. And the same, if someone is confused and they're saying no. So there's lots of considerations and lots of instances to be aware of where we might not be able to go ahead.
Thank you. And from the other side, someone is saying here that their family physician is not supportive of MAiD. So what would you recommend in that case?
So that's where, as I mentioned, if someone wishes to apply, they can do so without the knowledge of their family physician. So they can usually complete, so in BC, certainly someone can complete the referral themselves. They can have a friend or someone who's not a family member and is not a beneficiary in their will, can witness them signing the form, sign as a witness. And the only thing that the witness is saying is that this is in fact the person that I witnessed signing the form, and therefore I'm signing this and the form is submitted. So someone can also let the office know that they do not wish for their family doctor to know that they are accessing an assisted death. So that's well within their right as well.
Thank you. And one more clarification about the waiver. So someone is referring to Annette, the case study that you shared, and they
Yes.
said, so to clarify, Annette did not choose to die that particular day, but any time within the waiver of final consent period.
Exactly. So the waiver stipulates that if someone loses capacity, then they give consent to be administered the medication to help to end their life on or before the date chosen on the form. So for Annette, we had to go ahead on that day because it was the last day of the waiver. And after that day, we wouldn't have been able to, it would have been quite likely not possible to get consent from her. And also, we would definitely not have been able to set up another waiver for her. So that was the urgency for her. But otherwise, we could have proceeded any day before that if it was a longer waiver. So say maybe she was in the hospital, she had to go into care, then we could have proceeded maybe at that time when she had to go into long-term care. And I also mentioned in the presentation that someone has to experience intolerable suffering. So someone might wonder, how did I justify going ahead for Annette? Because she was in a safe environment. But for her, it was so distressing that she was in a confined unit. She couldn't leave. She couldn't go home. So that was causing her so much distress that I did feel that she met the requirement that her suffering was intolerable. So for her also in her advance directive and in our discussions, losing the ability to take decisions about her care was for her also something that was very distressing when she had capacity. So that was another aspect that I found that I felt supported my application to invoke her waiver as well.
Thank you. And another question here is, can the date on the waiver be changed to a later time?
So the date cannot be changed, but when it gets close to the expiration date, we can meet again, and provided that someone is then able to consent to having an assisted death, then the waiver can be extended again. So it is not a final date that is on the waiver that is chosen. It's always something that can be extended, provided that someone can still give that consent legally.
Thank you. Sorry, I'm just rapid firing the questions, but I just want us to get through as many as we can.
No problem. It's
I know
great.
a lot of
They're
people in the chat box saying they're really enjoying, really appreciating all this information. Another one that came up, I guess it's a question around access. So people are saying, how many nurse practitioners and doctors in BC can provide MAiD? How do you find two to assess your eligibility? And then they allude to the difficulties people have finding a family doctor. So are there issues around access? Is that a challenge?
We try to do the best we can. So each health authority usually has some providers who are who provide for more people, and then there's, because we all have other roles as well. So some of us will and then there are maybe some physicians who provide to one or two patients a year, maybe provide to their own patients and not to other patients. But of course, through different geographic areas, there's different service limitations. So some areas do sometimes set up a waiting list. And because someone would be falling under their own health authority's coordination service. So it's something that is different for each area. On Vancouver Island, it's actually the highest uptake for MAiD in the whole of Canada. And there, what we do find is that there's usually more family physicians who provide assisted dying, especially for their own patients. So whereas in an area like Vancouver Coastal Health, we have more providers who are and fewer family physicians who provide to their own patients. I myself have actually provided to 3 of my own primary care patients, and for them, the feedback that they gave me was that they really felt it comforting that they didn't have to meet a new person who didn't know them, and they were very grateful that I was able to see them through that journey as well.
Absolutely, and the connection you would have built up, I'm sure that provides some comfort. And so I'm seeing a question here. I think this speaks to an advanced directive, so I think you've addressed this, but just to make it completely clear, someone has asked, can I plan or give my instructions for my health directive for my own MAiD now before signs of dementia begin?
So currently this is not an option, but it is something that the legislation may change in the future. So it's hard to say what lies ahead, but currently there is no access for an advanced direct or for accessing MAiD through an advanced directive.
Yeah, perfect. And that leads me to another question that I saw earlier, which is what's the best way to keep up to date on any potential legislation changes?
So I would say the general news. There's also CAMAP, which is the Canadian Association of MAiD Assessors and Providers. So they do provide a lot of information about MAiD. There's also agencies like Dying with Dignity Canada. They have conferences as well. There is a conference, I think, in November in Toronto about the right to die. So if you keep an eye out for conferences, for talks in your area, but you can also sign up to become a member with Dying with Dignity. And I'll just say that I have no affiliation with Dying with Dignity, so it's just it's something that you can also access for more information as well.
Yeah, and we have a handout today, and we have included links to CAMAP and Dying with Dignity so that folks can check those out. So thank you. A great question here about young onset dementia, because they were saying that the cases you presented are patients in their 80s, and it might be a harder choice for the family of someone in their 60s with young onset Alzheimer's. Have you had any experiences with a younger candidate for MAiD? And so this person, their family member, is expressing wishes to end their life before they need long-term care, and they're wondering if this is the time to apply for MAiD.
You know, we would always take into account someone's whole picture. So, so certainly someone who is younger, whose dementia is becoming more advanced, could qualify. So we would take into account what someone's functioning was before their diagnosis of dementia and how it's impacting them. And what their concerns are for the future and how their suffering is right now. So certainly someone with dementia could qualify even if they're younger.
Perfect. Thank you so much. I'm looking, okay, yeah, so there's some other questions here, and they're about, folks where their dementia has progressed, so they might be nonverbal, no longer able to, talk, and so folks are wondering if MAiD is an option for them at all, but based on what you've said today, I think, it sounds like you need to be able to reason with people through the assessment and
Exactly.
communicate.
Exactly. So that's a great question because someone doesn't necessarily need to be able to communicate verbally. So sometimes we would get the support of speech and language therapy. We would, although this would be difficult, I think, for a dementia assessment, but sometimes we complete assessments with questions. The answers are yes or no. So we do look at other ways in how we can complete an assessment, but certainly for dementia, that would be more challenging. And certainly when someone gets to that point where they're nonverbal, they're not really able to express their suffering, it's unlikely that they would be able to qualify. So one of my tips would be discuss your wishes, your end of life wishes with your family members as far in advance as possible. And then also, when I would not say that it is too early to get involved with the assessment process, because it's something that you do need expert follow-up. So it's something that you can always just have a basic assessment with someone, and then you can have follow-ups or be linked with someone. So if you have concerns, then do reach out, because there is that component that if your condition becomes too advanced, then you may not be able to access it anymore.
Thank you. I'm seeing another kind of question or theme that came up, because we've already talked about it, it's the decision of the person alone. It doesn't come down to a family member's wishes. But if there are people who do have any sort of concerns about MAiD administration or concerns about misuse, what would you recommend?
Yeah, so we do, as part of our interview, we would usually ask any family members or friends who are present to step out. And then we do screen for coercion. We check if someone wishes to proceed because they're worried about being a burden to their loved ones. So we do those type of screenings in private. And certainly, if someone has concerns that someone's being pressured into accessing MAiD, then they could contact the coordination team. They can ask to speak to the provider, so they could certainly reach out and provide that information to them. So we, I think with that would be a good approach. Some of our care coordinators have a background in social work, so they do also try to screen for that as well in the initial stages.
Thank you. And I think I have one last question that I think it will be great to end this with. And it's a big one, so but I'll put it to you. They've asked, are there any ideas or concepts that you've rethought related to MAiD during your experience in this field? If so, would you be able to say anything about this that may help those of us listening now and attempting to frame our thinking?
That's an excellent question. Yes. So I think something that I've learned is that it's really that being able to access MAiD and the service of MAiD is something that can give people control in a situation where they feel that so much is outside of their control. And as I mentioned in my presentation, that knowledge that there is a way out can really help for someone to feel that their intolerable suffering is something that they can tolerate for longer, because they know that it's simply a phone call that they need to make to get another appointment set up, and that they can then move ahead. So I think for me, it's something that I've seen as well is that some people who may have wanted to go ahead earlier with assisted dying may actually have continued to live longer with their suffering because they knew that there was this option. I think it's really something that people are very grateful to be able to access this. And for me as a provider, it's always an honor to be able to be involved with someone's care in this way and to support them in this part of their journey.
Thank you so much. I think that that's a great note to end it on. And there we have our First Link Dementia Helpline. And so if you have any questions about information you've heard here, or any other questions about living with dementia, or if you're interested in any of our programs, we have support groups. We have a fitness and social program called Minds in Motion. Please don't hesitate to call our First Link Dementia Helpline. We can help you navigate resources and we can provide support for you. And I think just a final sincere thank you to Dr. Coetsee. It was really, really illuminating presentation and really appreciate your time and expertise on this topic.
Thank you so much, Avery. Thank you for having me today.